Hi there, how are you doing? My name is Mutiaba Conrad. I am a lawyer and a private law tutor. And basically, today in this video, we're going to be looking at the distinction between appeals and judicial review. Normally, this confuses students a lot. And in this video, we are basically going to unpack the differences between the two. So let's jump right away into the distinctions. But before we do so, I encourage you to subscribe to my channel. If this is your first time, ensure that you just click on that red button just in the right lower corner so that you subscribe. Also turn on your notification and then ensure that you can share this video with your colleagues so that they are able to benefit. Also, students that are interested in our private law tutorials, if you want to engage us for a private session, please contact us. Our number is down in the description box, and then we can assign an expert who is able to tutor you through your law school. Grades really matter, and tutorial sessions have been proven to be highly effective, and most of the students that have joined our tutorial programs have actually emerged top in their classes. So let's start right away to look at the distinction between appeals and reviews. The first similarity between appeals. We're going to look at the similarities, then we'll also look at the differences between the two. Of course, there are more differences between the two, and it is not true that these are similar. They are actually very different, although with some similarities. So similarity number one is that appeals and review are similar in a sense that they both seek assistance of another authority to reopen the matter which has been decided upon. So there is a matter. This is similarity number one. There is already a matter, whether under judicial review or appeal, which has already been adjudicated, and you're seeking a higher authority to reopen or to reconsider that decision that has been passed. So that is similarity number one. Similarity number two is that both are initiated by an aggrieved party. So when you look at judicial review, it is initiated by a party who is aggrieved by the decision of an authority. An appeal, it's the same. You only appeal if you are the person who is aggrieved. You cannot be the winner and then you appeal, then or else what are you appealing against? So again, we are seeing that that is similarity number two. In certain circumstances, however, a review may be applied for before a decision is made. This is important to note. The choice of either appeal or review depends on circumstances. Okay, it's always important to identify the most appropriate option after taking in account the law in place and the remedies it affords. Okay, very important to note. So having laid down those similarities, let's now proceed to look at the differences between appeals and judicial review. So difference number one is that appeals are creatures of statutes. Okay, appeals are creatures of statutes. This one I emphasize. There must be a provision for appeal. Otherwise, one cannot appeal. But where there is no right of appeal, one can apply for judicial review if there are grounds. So for appeals, you can only appeal if the law allows you to. For judicial review, even if the law doesn't allow you, but there are grounds, provided you have those grounds, as we'll be looking at them later on in another class, illegality, procedural impropriety, among others. If those grounds are available, then you can apply for judicial review. Authority for that position, I encourage you to go and look at the case of Attorney General versus Shah. It's a case of 1971, East Africa, page 50. And basically, in that case, the court held that a right to appeal is a creature of statute, and as such, no right to appeal is available if the statute in question does not expressly permit you to appeal. Appeals are creatures of statute. There is no inherent right of appeal. Of course, the exceptions, okay, we'll look at those under civil procedure. Or if you just go on this channel and you look at my civil procedure classes, there are those exceptions. But as a general rule, an appeal is a creature of statute, and where the statute does not allow you to appeal, you cannot appeal, and there is no inherent right of appeal. Let's proceed to difference number two. Appeals are usually about the merits of a particular decision to establish whether the decision made by a lower court or tribunal was correct. However, A review or in review, court is asked to review the decision by confirming whether the decision was reached following properly established methods or procedures. So under review, we are looking at the procedure, okay? Whereas under appeal, we are looking at the merits, whether the decision is correct. Under appeals, we are looking at the correctness of the decision. But under judicial review, here we are not challenging the correctness of the decision, but we are challenging the process, that the process through which the decision was reached was flawed. It was improper. It violated certain fundamental elements. Authority, I encourage you to look at the case of Chief Constable of North Wales Police versus Evans. It's a case of 1982, Volume 1, WLR, page 1155. And also in the case of Uganda Inland Port Limited versus Attorney General, this is High Court application number 145 of 2007. And basically, in this case, court stated that judicial review is concerned not with the decision. Please note, with the judicial review here, you're not challenging the decision, no. But what you're challenging is the decision-making process. The process within which the committee or the tribunal passed through to reach the decision is what you're challenging, not the validity of the decision. Very important to note. Difference number 3 is judicial review is constitutional. Okay, when you look at judicial review, it is constitutional. It's constitutional, i.e., it's provided for under Article 42 of the 1995 Constitution of Uganda, while the Constitution doesn't address itself to appeals outside the ordinary court systems. Very important to note. Difference number 4 is that judicial review must be based on some grounds. So judicial review must be based on some grounds specified, okay, i.e. regularity, illegality, irrationality, procedural ultra vires. But in appeals, one is only dissatisfied with the decision and that the conclusion or facts or on law is incorrect. Under judicial review, basically there are grounds, okay, it's based on the grounds. But here under appeal, you're not basing your appeal on any grounds, but rather you're only dissatisfied as to the correctness of the decision. That's the fourth difference. Difference number 5 is that under judicial review, okay, judicial review basically, it leads to particular remedies, very important, some of which may not be available on appeal, okay. For example, it's possible to apply for review before a decision is made. You can apply for judicial review even before a panel or a committee or a person makes a decision, okay. Appeals are not available before judgment. You can only make an appeal after judgment has actually been passed. If a judgment has not yet been passed, then you cannot appeal. Otherwise, what are you appealing on, okay? i.e. against procedure. Here, judicial review may not wait for the decision. So again, I emphasize, for judicial review, you may not necessarily even wait for the decision, because what you're challenging is not the final decision, but rather the process within which the decision is going to be arrived at. Whereas under appeal, you're challenging the correctness of the decision, and you cannot appeal unless that decision has been passed, because you are interested in the merits of the decision. Whereas that is not the case under judicial review. Very important to note. Difference number 6 is that appeals result into reversal or confirmation of the decision made earlier. But in judicial review, applications may be made for fresh orders, not connected actually with the earlier decision. Okay, this is very, very important also to note. Then lastly, the type of remedies sought will also influence the choice between appeal and review. What remedies are you looking for? There are some remedies which cannot be given on appeal. For example, those remedies under judicial review. And the reverse is also true. There are remedies under appeal that cannot be given under judicial review. Okay? Under the Judicature Act, prerogative remedies such as mandamus, certiorari, and prohibition are not available until the applicant has exhausted the ordinary remedies. that may be available under the relevant laws. So you cannot then proceed to get remedies such as mandamus, certiorari, prohibition, unless you have exhausted all the other available remedies. Okay, so that is also another difference for you to note. Authority for that position, I encourage you to go and look at the case of Fazal Kasam brackets Mills Limited. It's a case of 1960, East Africa, page 1002. It was stated in that case that the court will, as a general rule, and in the exercise of its discretion, refuse an order of mandamus when there is an alternative specific remedy at law, which is not less convenient, beneficial, and effective. So the moment there is any other benefit or any other rather remedy, okay, then court will not go on to give you these prerogative orders. If you ought to have exhausted something else, then court will not grant you the same. So basically, ladies and gentlemen, those are the differences between appeals and judicial review. Again, I encourage you to subscribe, to like, and share this video, and also to turn on your notification. And again, for students interested in private law tutorial sessions, please contact us. Our number is below down in the description box. We can always make these arrangements, and then we tutor you privately. Of course, these classes are not always extremely exhaustive because of time and many things, and trying to make the videos short. We always leave out some things, but we do our very best to ensure that these classes are as detailed as we can, to ensure that we give you the best that we can. So please, I encourage you to subscribe, to share this video with your colleagues so that they are also able to benefit, and then contact us for private law tutorial sessions so that we're able to help you build your legal career. Private sessions really work, and they always help students inform, or rather improve, on their academic grades. Thank you very much. We meet again in another class. Bye-bye.